Welcome back to our channel. For newcomers, thanks for joining. There are many rumors about the legal profession, some of which are true, most of which are not. The purpose of this episode is to address the myths about the legal profession and make evident the true state of affairs. This episode is important as many students choose the legal profession due to things they have heard and end up getting a real surprise when it comes to practice. Guys, before we get into it, please remember to hit that subscribe button and share our channel with your colleagues. It is greatly appreciated. Okay, myth number 1. Attorneys are rich as hell. How many times has someone told you that you're going to be rich because you're studying law? We have heard it countless times. Perhaps it's because legal representation can be extremely expensive, but what professional service isn't? What people don't seem to realize is that the fees paid for our services don't go directly into our pocket. Instead, the fees go to the firm and the attorney is paid a salary, and in some cases, commission. Some firms obviously may have different arrangements in place with their attorneys, but we are speaking generally here. In addition to the above, running a firm doesn't come without its expenses, of which there are many. That being said, once you become admitted, will you be rich as hell? The answer is no. We've touched on it previously, but candidates in most cases earn a pathetic salary, and newly admitted attorneys don't earn huge amounts either. Even in the bigger firms where attorneys earn more than the average, it would be disingenuous to say that they are rich. Should you be an experienced attorney in a firm with decent cash flow, you will most likely be financially comfortable. With experience comes higher pay. So after many years in practice, yes, absolutely you could be rich. It all depends on what you consider rich to be. You should in most cases, after quite some time in practice, be comfortable financially. In other words, lack of money is not your biggest issue. As mentioned above, there is a strong possibility of becoming rich. In other words, money is not a problem for you. But this takes time. It is hard to generalize here, as the legal profession is vast, but it should be understood that attorneys will only start to see the big bucks after quite some time in practice, taking into account their position in the firm and the fees that they write. Writing fees is so important, and the amount you write per month will indicate to the firm your value. For a discussion on salaries, check out our episode in the top right-hand corner. Myth number 2. The TV show Suits accurately depicts the legal profession. No doubt the immaculate suits, shiny offices, and high-profile clients portrayed on Suits makes your mouth water. Unfortunately, if you expect your life as an attorney to be like Suits, you're going to be disappointed. Yes, there are certainly aspects of the profession that the show gets right. However, it conveniently doesn't show the shitty sides of law. Obviously, as that wouldn't be very entertaining. Harvey Specter is portrayed as having an incredible amount of legal knowledge. Remember, you know very little when you start articles. It takes experience to build up your legal knowledge. Not every case you deal with is complex and exciting, unfortunately. We can't even tell how many straightforward debt collection matters we have dealt with over the years. Law is not that glamorous. Yes, the offices and advocates' chambers may be fancy, but court, far from it. A lot of the research by the attorneys on the show is done in the library using books. Yes, books are of great assistance, as to our law journals and so on. However, these days, most source material can be found online. South Africans also don't seem to sue for any silly reason like you see in the US and on US shows. If you want to sue someone for something petty, best know that there are many elements you need to prove, depending on the type of claim. You don't just get awarded billions in damages for spilling hot coffee on your lap. Suits also underestimates the pace at which attorneys work. The legal profession is a high-paced environment that can be extremely demanding. There's a reasonable amount that the show gets right, but for the purposes of this episode, we are looking at the differences between Suits and real life. We also aren't trying to be negative about our profession. We love what we do. Myth number 3. You'll be a great attorney if you're good at arguing. This one always makes us laugh. You may be a good debater if you're good at arguing, but not necessarily a good attorney. Actual argument only makes up a percentage of the tasks performed by attorneys. In most cases, attorneys appoint advocates to do the arguing on their behalf. A lot of arguing also takes place on paper by way of affidavits and in heads of arguments. There is so much to the legal profession, so if arguing is the only skill that you can bring to the table, you'll likely not succeed. Some of the other extremely important skills/traits required by a legal practitioner should include, inter alia, drafting skills, strong reading capability, accuracy and attention to detail, impeccable grammar and spelling, neatness, efficiency, ability to work under pressure, ability to adhere to time constraints, interpersonal mastery, listening skills, research competency, ability to summarize cases, rules, etc., superior focus, pure dedication, good attitude, and confidence. Should you possess some of the above crucial skills, then absolutely a strong argumentative side will be beneficial. Myth number 4. We have the jury system in South Africa. We do not have the jury system in South Africa. Guys, if your mate tells you that he has done jury duty, he's talking cuck. We do not have it in South Africa. And I'm glad, but that's just my opinion. The presiding officer adjudicates the matter throughout. Presiding officers are your magistrates, judges, justices, commissioners, and so on. Another myth, judges use gavels. You know that mallet-looking thing that the judge pounds and says, "Order"? Yeah, you won't see that in South African courts. Sorry to be the bearer of bad news. In fact, gavels aren't even used by judges in UK courtrooms. They are, however, used in US courtrooms, and that is likely why the gavel is so strongly associated with judges. But alas, not really. Another myth that we hear quite often is that you are an attorney once you have obtained your LLB degree. Nope, far from it. Once you've obtained your LLB degree, you are just a person with an LLB degree. You only become an attorney upon admission as an attorney. We will not go through this in detail again, as we address this topic in great depth in our series on articles of clerkship. But before an LLB graduate can become an attorney, they need to complete articles, pass the admission exams, attend PLT, and apply to be admitted, amongst other things. In this regard, check out our articles of clerkship playlist. It should be showing in the top right corner of this video. The next myth on our list is attorneys are always in court. 90% of attorneys will go to court during their career, whether it be for admin purposes or actual appearances, depends on the nature of work that the firm does. During articles, you should be going to court at least every now and then. With me personally, I was in court several times a week for both administration purposes, whereby I would be filing and issuing, etc., as well as appearances, which were mainly Section 65s, default judgments, and so on. Some attorneys will go to court way less than others, especially those in certain specialized fields. Attorneys only focusing on intellectual property will be in court less than those doing debt collection, for example. Attorneys also have the option of becoming conveyancers. There are not easy requirements that have to be met in this regard, but upon becoming a conveyancer, you will very rarely find yourself inside a court building. Conveyancers deal with property transactions. It is advocates that are most often in court. However, there are attorneys who prefer not to appoint advocates who will be in court almost as much. In Gauteng, the court system is mostly online now, so even less time will be spent in court. Therefore, the amount of time spent in court will likely depend on the nature of work done by your firm as well as your own personal preferences. The next myth on our list is that your law degree adequately prepares you for articles. This is a controversial point, and opinion may differ from person to person, but from our side, the answer is an unequivocal no. Your opinion may also differ depending on whether your firm is criminal or civil in nature, whether you have obtained a master's degree and are now practicing in that particular field, and so on. We are talking from the perspective of a candidate legal practitioner in your general firm focusing mainly on civil action, family law, debt collection, and so on. In this regard, we feel that university inadequately prepares us for articles of clerkship. Although we are speaking subjectively, we feel that university needs to focus 1,000 times more on civil procedure, the rules of court, drafting skills, practice directives, and certain acts, such as the Magistrates Court Act and the Superior Courts Act. Yes, we know that civil procedure is a module, but it should probably be one that is taught every year of the LLB degree. Furthermore, every other subject, such as family law, tax law, employment law, contract law, property law, and so on, should be about more than just the theory. The subjects need to be taught in a much more practical manner. For example, in contract law, once you've been taught the grounds for a breach of contract, you should be taught how to institute and defend legal action based on the breach in question and draft the relevant pleadings and notices. We understand that there are procedural and drafting components of the various subjects. However, it's nowhere near enough. There is no point being able to recite the Income Tax Act when you don't know how to draft a plea. We are not at all saying that university is a waste, but we are saying that it probably needs to assess students in a more practical, real-world manner. Moot court should also be a yearly thing. In addition to the manner in which modules are taught, university does not teach students enough about articles of clerkship. Students need to understand exactly what is expected of them when it comes to articles and the formalities they need to comply with. We have done an entire series on articles due to the lack of information students and new candidates have. Do not stress about being unprepared though. You will learn on the job very quickly, and your seniors encourage you to ask questions. We have all been in the same boat. Advocates are better than attorneys. This is like comparing knee surgeons with hip surgeons. Being an advocate and being an attorney are two different professions. Advocates have to do pupillage and pass the bar exam, whereas attorneys must complete articles and pass the admission exams. Most advocates practiced as attorneys prior to their admission to the bar. We will do a separate episode on the differences between the two professions. However, by no means are advocates better than attorneys. This is a generalization. A junior advocate with a few years legal experience does not know more than an attorney practicing for 40 years. Advocates are specialist litigators, so their knowledge of the court rules is exceptional. An attorney, however, would very likely be better equipped to draft a contract, for example. Advocates, unless they are trust account advocates, do not deal with clients directly, but are rather briefed by attorneys. The admin aspect, which is extensive, of legal proceedings, is therefore dealt with by the attorney in question. An attorney will refer matters to advocates when the situation requires. This is mostly done when the attorney requires someone to appear on their client's behalf at court, or where complex pleadings or notices need to be drafted. Instead of comparing the two professions, rather consider both to be very highly regarded. You can sue people for billions of rands in damages. You may have heard of Liebig versus McDonald's restaurants, which was a US case wherein a 79-year-old woman suffered third-degree burns to her pelvic region when she accidentally spilled hot coffee in her lap after purchasing it from a McDonald's restaurant. Liebig was hospitalized for 8 days while undergoing skin grafting, followed by 2 years of medical treatment. The jury damages included $160,000 in compensatory damages to cover medical expenses and $2.7 million in punitive damages. The trial judge reduced the punitive damages to 3 times the amount of the compensatory damages, totaling $640,000. The parties settled for a confidential amount before an appeal was decided. Take note of the concept punitive damages. In South Africa, a plaintiff may not claim punitive damages from a defendant in a private claim, as this is seen as being contrary to public policy. A plaintiff is only entitled to the damages that he or she can prove that they have suffered. A plaintiff may, however, claim constitutional damages, which is similar to punitive damages, but successfully claiming this type of damages is not an easy task. In terms of our law, the aim of a claim for damages is to compensate for the loss suffered and not to enrich a party. A claim for damages may be instituted by a plaintiff, 1. in the event of a breach of contract, 2. in the event that the defendant has committed a delict against the plaintiff, or 3. where there has been a breach of statute that provides for an award of damages or compensation in the event of such a breach. Each of these causes of action require that certain elements must be proven. Therefore, you will not be awarded a filthy amount in damages as a punishment to the defendant. If you think you can make a quick buck by deliberately slipping on a shopping mall's floor and claiming damages in an exorbitant amount, think again. Attorneys are sharks simply after people's money. This is unfortunately another generalization of the legal profession. A shark is a rapacious, crafty person who takes advantage of others often through usury, extortion, or devious means. Yes, there are sharks in the legal profession, but there are far less of them than there are ordinary ethical attorneys. As with any service, do a bit of research or seek recommendations before appointing an attorney. Be very careful with touters. They are the attorneys hanging around courts and police stations offering to assist you, provided you pay a nice upfront deposit. These guys are dodgy. Most attorneys are very passionate about their cases and their clients. If it doesn't seem that way, it's because we have learned to keep our emotions under control. If you consider your attorney to be a shark because his services are expensive, bear in mind the following. Attorneys are professionals. It takes us around 6 to 7 years of studying before the title of attorney is acquired. After obtaining the requisite degree, we still have to write admission exams and complete both articles and practical legal training, amongst other things. When you hire an attorney, you are buying our knowledge, skill, and expertise, which takes years to accumulate. The responsibility on attorneys is hefty, and you pay a premium for that. If you are charged with a criminal offense, an attorney can help you avoid jail time. If you're getting a divorce, an attorney can save you a lot of money in the long run. The same applies to most instructions received by attorneys. Think about where an attorney has to interdict someone from putting your life in danger. You'll also not realize the amount of work that goes into representing a client, especially behind the scenes. From admin to drafting to arguing in court, the work is extensive and time-consuming. Attorneys' fees are often not covered like your hospital and medical expenses are. Our fees therefore seem exorbitant because you actually have to pay for them out of your own pocket. Remember that should you be successful with your case and have judgment granted in your favor, the court will usually order the opposing party to reimburse your legal costs on a specified scale. If you are seriously aggrieved by the invoice you receive from your attorney, you are entitled to a query same with the Legal Practice Council. To summarize, you buy a lot with your money. We deal with problems on your behalf. We apply our hard-earned knowledge, skill, and expertise for your benefit. Regardless of the skills we possess, we are still required to spend hours and hours on research, drafting, corresponding, court attendances, and admin. We do this while simultaneously managing a costly business. Our final myth is that attorneys enjoy assisting family members and friends. At the beginning, sure, it's exciting to be in a position where you're able to advise your family and friends on legal matters. Perhaps it made us feel important and knowledgeable. However, once you start dealing with your own matters and gain considerable knowledge of the law, helping out family and friends becomes burdensome. The reason why we say this is because this help often comes for free or at a considerably reduced price. Sure, if your friend is willing to pay for your services, no problem. Upon admission as an attorney, you'll have a fee target every month coupled with a shit ton of work. Finding time to assist mates for free is not an easy task. As an attorney, your time is precious. The worst is when a legal favor is requested from friends whom you haven't heard from in years, or from your uncle's nephew's horse's adopted child. It's always fascinating watching these guys creep out of the woodwork only when something is needed. Of course, it's not only payment that's an issue when it comes to representing friends and family. There's an emotional aspect too. It is important as an attorney to make sure that you don't become too personally invested in a matter. You don't want your emotions to override your logic. If your close family member is seeking legal assistance, consider handing the matter to one of your colleagues. You may always oversee the matter, but this way you'll be less invested emotionally. You also need to be wary of a conflict of interest. The point of addressing this myth is not to tell you that you mustn't help out your family and friends. You may absolutely assist them, just don't let them abuse you. Know when to draw the line. And that's our episode. So, to conclude, we hope that we haven't crushed your expectations by busting some of the legal myths herein. Rather know now what to expect, instead of receiving a bleak surprise when you commence articles. If there is a misconception, rumor, myth, whatever that we have not discussed, leave a comment or hit us up on our social media pages and we will address it. Please, if you enjoyed this video, hit that subscribe button and share this channel with your friends. We also have a Facebook and Twitter page, so give us a follow there too. The links are in the description. Our website will be up soon as well. Cheerio.